And so even though you think, oh, yeah, this case is worth X, you think it's worth X because of the information that you have. But it's the information that you don't have. That's what you need to find out. And that's really where, as a mediator, it's such a great position because you start in a very different scenario to the other side. Because generally speaking, you've got both parties. And if there's a delta between the two, it's simple. You know the case is going to settle.
Hello and welcome to the Attorney Post, where we give you the inside scoop with top attorneys in their field. And now, here's our host, Justin West.
All right. Hello, everybody, and welcome back to the Attorney Post, where we discuss what's going on in various facets of the law with attorneys at the top of their game to help you navigate the ins and outs of various legal fields and jurisdictions. Because, as I always say, if you don't know your rights, you don't have them. Speaking of knowing your rights, today I am joined with Nigel Wright, who is another mediator down in Georgia with Henning Mediation. We talked with Judge Randy Rich earlier this week, so we're having a back-to-back with him today. Nigel, how are you doing today?
Good, thank you.
Awesome, awesome. Well, we're going to jump over and we're going to go ahead and give Henning another shout out here since you're the guest on our podcast. Nigel is a mediator with Henning Mediation Services, celebrating 25 years, a 25th anniversary as the gold standard in dispute resolution. If you have need of mediation services, especially if you're down in the Georgia area, you can look up, as always, Henning Mediation. Their link is down below in the description. As always, that is henningmediation.com. We are going to read from our sponsors today, the same sponsors we had with Judge Randy Rich. The first sponsor is Rank with News. Is not being found in the news regularly costing your law firm or your business credibility and visibility? Do you feel that getting found in Google is more about dumb luck than science? What if there was a guaranteed way to get your law firm or your business featured in major national publications like Yahoo News, Bloomberg, Reuters, AP News, etc., and then to see those articles ranking locally, even nationally, sometimes in under 8 hours for major competitive keywords that people were actually looking for? Well, if that was the case, what else would you need to know? Rank with News is simply the most powerful way to hit page one in 2 weeks safely, organically, and most of the time permanently. This is like guaranteed SEO or search engine optimization on steroids, ranking quickly and sticking long term. If you're tired of poor visibility for your business or firm, visit rankwith.news to learn more and book a time to speak with a specialist about featuring your firm or business in major national 8 and 9-figure traffic sites that could launch you to page one in a matter of hours and help you dominate your local marketplace. Get media exposure, rank higher in Google, build credibility, and win more customers and clients with Rank with News. Our second sponsor is Anthropology. Gentlemen, if you would like to take charge of your health this year and feel your best, listen up. Whether it's managing type 2 diabetes, boosting your testosterone later in life, or just wanting to increase your overall longevity, Anthropology.com has got you covered. They dive into deep into natural solutions like superfoods from spirulina to tart cherry extract and targeted fitness routines like HIIT, high intensity interval training that can help you reclaim your energy and your vitality. At Anthropology.com, it's all about practical science-based advice tailored specifically for men who want to improve their health without all the fluff. Think of it as your go-to guide for navigating the complexities of men's health. Simplified. From diet tips to supplement recommendations, they have everything you need to start making positive changes today. Visit Anthropology.com and explore the latest insights on living a healthier, more vibrant life. That's Anthropology.com, where better health for men begins. Alrighty, we'll get rid of that. And we're going to jump back over here. So I am again talking with Nigel. So again, hello and good afternoon, Nigel.
Good afternoon, Justin. Thanks very much for having me on today.
Absolutely, my pleasure. Nigel is another seasoned mediator and arbitrator with Henning Mediation and Arbitration, offering more than 30 years of experience in insurance, reinsurance, and commercial litigation. Throughout his career, he has held significant leadership roles in international insurance carriers and law firms, managing complex, high-exposure claims across multiple jurisdictions. His expertise spans a wide range of disputes, including coverage issues, bad faith litigation, and commercial arbitration, with particular focus on multinational and specialty claims. Nigel's also an adjunct professor at Emory Law School, where he teaches alternative dispute resolution, demonstrating his passion for mentoring and professional development. His commitment to fairness and his meticulous approach to dispute resolution has made him a highly sought-after consultant and arbitrator. Outside of his professional work, Nigel is also dedicated to community service, volunteering with organizations like Habitat for Humanity and Fur Kids. That was a mouthful to say. I feel like I stumbled over my words occasionally, but that's just life sometimes. And I'm sure, even as much as I had to say there, Nigel, I'm sure I missed a lot. So, my very first question to you, as always, is what did I miss?
Well, you probably missed the fact that we have two pound dogs, rescue dogs, who are probably going to bark at some stage during this podcast. So apologies to the listeners for that. But if it happens, it happens.
That's totally fair. I have, let's see, what time is it right now? I've got about an hour before my dog starts barking. So once my kids come home, he gets really excited. He's a big half German Shepherd, half mutt, and I think he has Beagle in him because he does this little like the Beagle whinny. It's just the funniest thing ever. So I'll put up with your dogs. You put up with my dogs. Everybody's good.
Fantastic.
Outside of the dogs, what did I miss?
Well, I'm married. I have three children, and we're about to be empty nesters, which we're super excited about, and probably a little bit nervous about as well, because nobody really knows what's going to happen. So it should be good.
I don't know how kids feel when they hear their parents say, "We're about to be empty nesters, and we're excited about it."
Yeah,
That's
by the
okay.
time the
Okay.
third one comes along, I
Yeah.
know, Justin, you have more than three, so you're a few years away from it, but
Well, and our
you'll get
youngest
there.
is 6, so I've got at least 12 years to go before the nest is actually empty. I turn 45 this year, so I will be 57, I think, before we have an empty house, but that's okay. I like my kids. I lost the receipt on them years ago anyway, so I can't take them back, so you better just learn to enjoy them, right?
Got it.
Well, Nigel, again, I had the chance to talk to Judge Rich earlier this week. So we've talked a little bit about Henning, but why don't you give me your take on the firm? Why do people choose to work with Henning? Why do people choose to work with you? What sets you guys apart from other mediators? And who should be looking to work with you guys?
That's a great question. I mean, the first thing is from in terms of Henning, it was a really weird scenario because about 5 years ago, when I almost joined Henning, when I first qualified as a mediator, they're literally under 10 minutes away from where I lived. Anyway, I ended up joining another platform, and for whatever reason, it wasn't quite what I wanted to do in terms of mediation. And it's taken me a little while, but I've got back to Henning. And I've got back to it not just because it's 10 minutes down the road, but also they're really kind of the gold standard in terms of they've been around the longest. They know what they're doing. They're fairly conservative, which I kind of quite like. I just feel that your mediator or your arbitrator shouldn't really be in your face. Your mediator or arbitrator should be about trying to help you resolve your case. And that's really what their role is.
Gotcha. Um, that makes sense. Pretty straightforward. So, what got you into law? And I notice a bit of an accent in your voice. I'm assuming you're not U.S. born native. Not questioning your citizenship by any means, obviously. But tell me a little bit about where you're from. What got you into law? What brought you into doing mediation? And tell me the journey that brought you here, Nigel.
Like most people, it's sort of circumstance, happenstance, whatever you want to call it. But many, many years ago, we were on holiday with some friends, and uh, the the father of the other family was a big time, what's called a barrister. So they're basically a trial attorney. And he was very, very charismatic, just was really engaging, had a great personality. And I just said, I want to be that when I grow up. And in the UK, it's slightly different because obviously I'm originally from the UK, although I've been here for over 20 years now. My wife's American, and we've lived in Atlanta the entire time. But when I kind of started thinking about it, it just seemed very logical. Just go to law school, go to college first. In the UK, there's an emphasis on you go to college to basically do what you're going to do subsequent in life. So I took 3 years studying law, then you do law school afterwards, then you qualify, you have 2 years of practice. And really, before you know it, you're just on that train. You're just going through the process. And it wasn't really until I would say, I did like a secondment, what we call a secondment, a summer holiday job, if you like, with a top law firm in London. And I came across this aviation lawyer who, again, was super charismatic, was very much engaged, had great communication with his clients. And I just thought that what he was doing was 10 times more interesting and exciting than basically what everybody else was doing. So it kind of really struck me. That's what I wanted to do. So I continued. I became a partner in the probably preeminent aviation liability law firm at that time. I mean, they probably say they still are. And it was based in London because probably about 70% of the world's airline fleet is insured in a lead capacity. That's a decision-making capacity in London. And so that's what I did. So I started there. And I mean, it's one of those difficult things. Like, I feel like I'm talking a lot, which as a mediator is probably not the best thing to be doing because you're supposed to be listening. But anyway, after I had done that, and I'd done it for a number of years, and DLA Piper came along and they said, "Would you like to set up an aviation department?" So, being young, naive, and all the rest of it, I said, "Yeah, why not?" So that's what I did. So after about 7 years at my first firm, I joined DLA Piper, set up their aviation department. I was there for about 7 years. And then, shockingly, somebody from the US came along and said, "Would you like to set up an aviation department or join our aviation department in the US?" So I said, "Yeah, why not?" And so I did that for 9 years. And then ultimately, the insurance company called Catlin came along and said, "We're a little bit fed up with paying for you. Would you mind coming in-house?" And they made me, as they say, one of those offers you just can't refuse for different reasons.
Hopefully, it didn't involve concrete booties.
Not quite, no.
Well, rest assured, you're a podcast guest, so talking a lot right now is actually very much encouraged. So, no worries there. So now you're at Henning, and you do mediation. You've traveled internationally. You've worked in different places. I'm curious. I didn't I didn't say this question beforehand, but I am kind of curious since you have more of an international perspective. Obviously, 4 or 5 years ago, the whole world kind of shut down for a little bit. We had COVID.
Yeah.
And I talk to attorneys all over the place. Sometimes I love to get like just the local feel because I talk to attorneys in New York City and California and Kansas City and Texas and Florida and everywhere. And they all had very, very different experiences of the pandemic, both for them, for how they interface with clients, how they interface with the law, et cetera, et cetera. So I'm kind of curious if you had any keen insights on that whole process, or how did the reaction to the pandemic affect you, affect your role as a mediator, as a all the things that you do?
Well, I had just started mediating full time when the pandemic came along. So, with phenomenal bad timing, that was kind of my story. But what I learned very quickly was to use Zoom. And so, what I found after the first month or so was that most attorneys were actually pretty relaxed about using Zoom.
Yeah.
And what was really interesting from my perspective was that it was relatively easy to settle cases early on in the pandemic because a lot of the plaintiffs, particularly in the personal injury casualty world, they wanted the money, so they were prepared to settle. Nobody knew what was going to happen. And then basically about 6 months into it, things started to change over. And all those attorneys and lawyer and plaintiffs who weren't in need of the money for whatever reason and weren't prepared to settle, they started working their cases up, and obviously cases became much more expensive. And the rest, as they say, is history. Because if you look back from the valuations back in 2019, at the beginning of 2019, through today, I think most people would agree there's been quite a significant increase in terms of valuation. So from my perspective, it's been interesting to watch that. And I think also understanding the financial dynamics of an insurance company, and in particular the interaction of reinsurance, the segmentation within those carriers, and how to get decisions made, has given me tremendous insight, and also helps, I think, in terms of trying to get cases resolved.
Gotcha. Yeah, I do think it's interesting just how everybody experienced the pandemic. I actually rebooted this podcast because of that pandemic, because all of a sudden attorneys knew how to Zoom. It used to be I had to walk them through. We used what was called Google Hangouts at the time, and it was this really archaic by modern standards process of recording everything. Oh, it was kind of a nightmare, and you had to like walk them through it and getting it set up every single time. Whereas everyone Zooms now. Like everyone just
Yes.
intrinsically knows
Yeah.
it. And if they don't Zoom, they Google Meet or they what is it, Teams or whatever Microsoft's version.
WebEx, Teams, everything. Yeah.
But everyone knows Zoom. I don't have to convince people to, hey, you got to download this software. Trust me, it's not going to ruin your computer. So it definitely sped things up for me. And it's kind of neat to see how attorneys are, zipping around even the world and able to zoom in, multiple nations at the same time. It's like by location all over the place, right?
Yeah.
Which is awesome. So let me ask you this. You've been practicing for 30 years. You've clearly got experience. You've got 30 years of legal experience anyway. And obviously you spent a lot of time doing aviation and stuff, which is
Yeah.
fascinating. I am sure here is an Americanism to say no, nobody bats 1,000, right? You bat long enough, nobody bats 1,000, your percentage goes down. Everybody has failures at some point in their career, but I think what defines people for the most part is what do you do when you get a failure, when you fail, right? Do you languish in it and just like, oh, woe is me, or do you learn from it and you carry on? I find most people that I talk to are very successful. They've learned from their mistakes and they carry it forward. So what's one of the times, Nigel, in your practice, in your career, where you failed, or you experienced something that would be considered a failure, mediation that went awry, a decision from a judge that went this way, whatever it happens to be. But what did you learn from that, and how do you carry that forward to make sure you're always bringing your A game?
Great question, Justin. And just to let you know, I'm not going to start with the usual LinkedIn answer, which is a failure that actually looks like a success. This is an actual failure. So I had a case when I was in-house with a carrier, and cut a long story short, I actually attended a mediation, and it was a multi-party dispute. So I had to physically go along. I had to be the person who was representing the pay-in party, which in this case was the insurer. And I offered a certain amount of money because I didn't really feel we had an exposure. And ultimately, that amount was rejected. And probably about 2 or 3 months later, there were certain factual developments, which I won't go into, not least of which because I might get sued if I say what I think happened. And to cut to it, the amount that I offered was just inadequate. And emotionally, I found it really difficult to offer more money. So let's say that I was offering $2 million and now the case was worth $6 million because of whatever had happened, but it was very difficult for me to really change course. And so what I learned about that was claims don't always get cheaper. I mean, sometimes they do, but generally it's very, very rare. Claims generally get more expensive. And what I have found in mediation is that's actually something that's super helpful because if you turn around to most clients and who are the paying party and you say to them, okay, so yeah, the claim's worth whatever you're prepared to offer, that's great. But if they don't accept that, what's the claim going to be worth in a year, 18 months' time? Is it going to be
Yeah,
worth more? Is it going to be worth less? And that doesn't mean necessarily that either one party or the other is going to accept full value, because very often parties try to negotiate a deal which is less than full value, whatever full value happens to be. And they do that because obviously you haven't got the cost of trial, you haven't got the exposure, etc. But it's very, very difficult for parties to contemplate that claims could have a different value in 6, 12 months to what they have today. So that I think has probably been one of my most helpful things to have learned. I think also I did a lot of coverage work for reasons that I could go on for hours about, which is fairly unusual for somebody to both do liability and coverage. So, but I did coverage, and one of the things I found was that basically about 20% of the cases you expected to win, you lost. And 20 of the cases you expected to lose, you won. And so there's just a certain degree of unknown, even on something as dry as coverage, which ought to be a strict legal analysis. There are still issues that you just cannot be sure about. And so then the question is, okay, are we taking this case to trial in front of a judge on coverage to know what the answer is, or are we taking it to the Court of Appeal? And those are kind of two questions you need to think about.
gotcha. How do you come up with A settlement offer. I mean, it sounds like a basic question, but like, how do you weigh, is this enough? Is this not too much? I mean, and I'm sure part of it's just a gamble. Part of it really is like, well, I think they'll take this, but they may not. I think this is enough, and but not more than we would need to. Like, this could settle for 10 million, this could settle for 2 million. I think if we go in at 4, we have a good shot. How do you do that calculation?
I think a lot of it's just risk assessment. So you look at the value of the case, whatever it happens to be, and you say, what could go wrong, what could go well. And so it's really about, so that's one of the things I love about mediation. It's really exchanging information in exchange for clarification of what your risk exposure is. So if a lot of people think that a claim is worth X amount of money and they're absolutely adamant on it, but they probably haven't taken into account the risk assessment. So for example, let's take commercial litigation, because a lot of people think that casualty, personal injury claims are kind of the most emotional, but that's not necessarily the case. Sometimes you get some very emotional C-level people because they're the ones who made a decision that the case is worth something, and they're not used to people saying that they're wrong. And so having the credibility to be able to say that and be able to say it in a way which isn't going to significantly upset them is very, very important. But the point I'm really trying to make is that when you're doing these kinds of cases, what you do, in my experience, is you need to feed enough information to explain to them that their risk assessment is wrong if it is wrong. I'm not one of those mediators that believes in shuffling one offer back from one room to the other. I do have an opinion. I do like to share my opinion, and I also share it with both sides. It's not like I'm, pro one side or pro the other. But what I like to do is really start with, have you contemplated this risk? And why don't you think that this risk is worth anything because your valuation hasn't given it a risk? And it could be because somebody's demanding too much money, and it could be because somebody's not offering a lot of money. But generally speaking, it's understanding the risk tolerance of the parties and getting information exchange from those parties to enable the other side to move what their risk assessment is, assuming that one of the parties is pretty accurate.
Makes sense. It's really just actuarial tables at the end of the day.
Well, you could argue, but the thing that's fun about mediation, and this is a lot of people have talked about AI, is it going to really impact it? And the answer is like yes and no. The really good lawyers are so adept at holding back information, and so even though you think, oh yeah, this case is worth X, you think it's worth X because of the information that you have. But it's the information that you don't have. That's what you need to find out. And that's really where, as a mediator, it's such a great position because you start in a very different scenario to the other side. Because generally speaking, you've got both parties. And if there's a delta between the two, it's simple. You know the case is going to settle. Most cases, there's no real delta and there's a gap. There's just a difference between, they don't overlap. And so you've got to understand, why is it that they don't overlap? Is it because they believe too much in their case? Is it because they haven't properly assessed what the exposure might be or what could happen? And sometimes you just don't know. Sometimes one of the parties is very, very good at not telling you what it is. So what makes it fun?
It's like a detective story almost. You really have to get in there and
It kind of is, yeah. Yeah, and you've got to get people to trust you. They've got to be willing to share, and they've got to be willing to share not just with you as the mediator, but with you and the other side. So you might turn around to me, and don't forget, everything is confidential in a mediation. You're only supposed to disclose what you're authorized to disclose. So if somebody turns around to me and says, "Oh yeah, this is in reality, we'll accept $100. That's all. That's all we need. We just want $100 and an apology." That they might say, "Oh yeah, but don't tell anybody."
Hmm.
And you say, "Well, hang on a moment. Okay. Why?" "Well, we think that blah, blah, blah," whatever it happens to be. So you have to be super careful on confidentiality. You have to be really, really clear that you are neutral, which is one of my favorite topics to talk about in terms of mediation. And you also have to be pretty good at getting parties to open up to you and then be willing to open up to the other side, because that's how you get movement.
What do you do if somebody says that to you? We'd settle for $100 an apology, but we think the case is worth $1 million, right? Do you tell the other side if they're like, but please don't tell them because they're asking you that in confidentiality, or at
You
that
can't.
point, if you're a
You
neutral,
can't.
tell
If you're a neutral, confidentiality is really at confidentiality and neutrality are at the absolute key of mediation. And so one of the things that you have to be really good at is first of all being completely neutral, which means that you can't favor one side or the other. You might have a view, particularly when it comes to legal arguments, but that's not what your role is ultimately. You might share that, but it's your opinion. It's not a legal analysis. What you're really doing is saying, look, um, I need to get the parties to settle because the goal of a mediator typically is to get a case to settle. But it isn't necessarily the goal of the parties. The parties may be to get discovery for free, to narrow the issues, to find out how much the other side is willing to contribute or pay at this particular juncture in the case. It may be to test their risk assessment on certain cases. They may have a completely different reason for going to mediation. But you, as the mediator, that's not your job, is to try to get them as close as they possibly can so that they can reach a resolution. And that's so sometimes you have a little bit of a conflict. So there's the neutrality is very, very important as well as the confidentiality. And again, that I'm not a probably not as good a salesperson as I should be. I'm a great believer that if you do good work, that should count. Now, it probably doesn't because in reality, mediators are great salesmen or women. That's what they're doing. They're selling to one side or the other why they need to move. And secondly, they're selling why they should be retained. I mean, I'm on this podcast because I'm trying to get more people to retain me. That's the reality. But even that, in my personal view, you have to be neutral. You have to be, consistent in what you do. And again, one of the things I find really surprising is the number of mediators that comment favorably on a big defense verdict or a big plaintiff verdict. And I just kind of thinking, if I were the other party, how comfortable would I be with that person being my mediator
yeah.
if they're congratulating somebody who's on the other side? I just genuinely don't get it. Maybe it's because I'm English, maybe it's because I'm old-fashioned, who knows? But I find that a bit strange. That doesn't mean you can't celebrate somebody being a partner for X number of years or making partner or, you know, joining a firm or leaving a firm or whatever it happens to be. But I'm not a big fan of uh, commenting on verdicts because I don't think that really reflects well on you as a neutral. And really that kind of brings me neatly, I think, to commercial litigation. So if you're doing commercial litigation disputes, generally speaking, people research the mediator at great length. And the reason they do that is because they're looking for just a little grain of bias that's going to support them. And in addition to which, is generally speaking, on commercial disputes, you don't tend to agree, oh, let's agree Nigel. He'll be our mediator. That's great. What you tend to do is offer a set of three mediators. And you say, okay, pick these three. And where Nigel is on that particular list of three is kind of important. So there's a lot of strategy. Should they be first? Should he be third? Even if he's my first choice, am I more likely to get my third choice selected than my first choice or second choice? And so if you're on the other side, what you're going to do is you're going to research that person on LinkedIn, on social media, on literally anything you can do, because your client's business or business interests are going to be dependent, in your view as an attorney, on whether or not you feel that mediator is going to be fair and balanced. Now, regrettably, very few people do that. And Justin, I saw, and I'm very glad you did this because I was desperately trying to find you on LinkedIn. I saw that you looked at me at LinkedIn, and I looked at you on LinkedIn as well beforehand. And it really shocks me even to this day, the number of mediations I have where neither party has actually searched me before the mediation. And I think, well, hang on a moment. Yes, I'm confidential. I know that. Yes, I'm neutral. I know that. But how do you know? You know,
Yeah.
how do you know what my experience is? How do you know whether or not I could be a good person for this particular fit? And so I think that I mean, what I would like to see in this particular industry is I think that the parties need to spend a little bit more time considering who they use as a mediation, as a mediator. So for smaller cases, maybe, and I don't want to be dismissive because obviously for each individual involved on a small case, on a personal injury case, it's critically important. But for financially smaller cases, maybe it's not that relevant. Maybe the plaintiff lawyer says, I don't care because this claim's only worth X or it's going to be worth X. And the defense side says the same. Maybe the same on a commercial dispute. Hey, there's only $100,000 involved commercially. From my client's perspective, it's not that big of a deal. There's no point of principle. There's no IP dispute. This is a breach of contract. You know, we either do or don't think we should pay, but it's not going to be very much. In some ways, the mediator there's just helping the parties, protecting the confidentiality of any discussions, and helping the parties who are basically resolving the case themselves. But for more expensive claims, that's not the case. You really do need to understand why, who your mediator is, what are their skills, what aren't their skills. Justin, one of the things that I loved when I was in private practice, and of course I love now as a mediator, is being told by clients what a terrible experience they had with somebody other than me. You're sitting there thinking like, yeah, but you should have actually used me and maybe you wouldn't have had that experience. And it happens so many times. Even as a mediator, it happens a tremendous amount of times. People go, oh, I can't believe I had 3 mediations last year with so-and-so. They were terrible. And you're thinking, well, the first time, okay, maybe you didn't understand. The second time, it's probably on you. But the third time, that really is on you. And so I don't think people really do enough research in terms of who they're using. So in my view, a lot of mediators, have an alignment with one side or the other. Well, that might be okay if they're neutral. But I would personally want to know that they were neutral. I wouldn't just take their word for it. I would say, okay, so you do a lot of defense work for these type of people. You do a lot of plaintiff work for these type of people in your private practice. And, why would you be a good person? You may have the subject matter skill set, but you may not position yourselves. If you've written a whole bunch of posts saying how terrible, plaintiffs lawyers are, or how terrible defense lawyers are, or insurers on an insurance case, then, why would you choose somebody who's aligned with that? I don't know. I don't understand that, but that's just me.
Yeah. Well, you mentioned earlier, even when we were talking beforehand, that a good part of how mediators get selected is just it's a sales gig, really. It's them presenting themselves, it's them selling themselves. But it's interesting because they're presenting themselves as the expert. Somebody still has to buy. I mean, quite literally, somebody has to have that buy-in. How do you separate out if you were in charge of picking mediators, you're not the mediator yourself, but you have to choose. How would you go about making sure you had somebody? I mean, you kind of hinted a minute ago. You said, you only do these kinds of plaintiff cases, you only do these kinds of defense cases. How would you make that final call? Is social media, is LinkedIn the most important avenue for getting to know a mediator? Do you snoop them out on Facebook or Twitter? Are there in the pre-social media world, was it more of a gamble or less of a gamble than it is today?
I think it's probably less of a gamble in a way because there wasn't as much information. I think what's really interesting is there's a really simple solution. Let's pick the phone up. If you want to choose somebody as a mediator or the other side want to choose that person as a mediator, pick the phone up and talk to them. Ask them the questions. There's a possibility they may not be straightforward with you, but you'll either know from other people or not whether they're a straightforward person, and just ask them the questions you want to know. Great example being, hey, you do a lot of work for this type of client. How can you be neutral in my case? They may have a great answer, to be fair, and it may be they may say, you know what, I do, but I think that this particular, you're telling me about your case, or you want me to mediate this particular case. I do think I can help because, and the because might be a great reason, because I happen to know the other side really, really well. And I think that they're being unrealistic in the way they're positioned. Or from what you've told me, I think they're being unrealistic. And actually, I think I'm in a better position to persuade them to, resolve their case. But don't forget, you've got to have the same conversation with them, the other side as well. And you've got to be able to say, look, it's great you've chosen me as a mediator, but that doesn't mean I'm on your side. My job as a mediator is to be neutral, and that means I need to work with two. I mean, sometimes I had a mediation the other day. There were 9 different parties. It was a bit of a shock to me at the time because I was the only mediator. but uh, but you have to make sure you have no connections. You have to be able to talk to each person, and you have to make sure their interests are respected and heard.
When there's 9 different parties, especially if you're the only mediator, how do you handle the balancing act, right? How do you weigh them, and how are you truly neutral with 9 different parties?
Well, first of all, great question. It was quite a challenging mediation personally. I found it quite challenging. But ultimately, what you can do, and a lot of people who do property mediations, property disputes, commercial property disputes, know this fairly well. You can basically group people together. So you might have, let's just say it wasn't, but let's just say it was a property. You have subcontractors, and so the issue of subcontractor liability and the availability of whether are coverage issues, whether how much insurance, etc., is one side of the equation. And then you've got the GCs. On the other side, you may have risk transfer issues that need to be dealt with. And then ultimately, you've got the plaintiff or plaintiffs, and again, they have their interests. So again, I think a lot of it's to do with how much work the mediator does. So on a personal level, I've got to be careful about giving absolutes because there's always going to be an exception. For example, I do a lot of short form mediations, really kind of for fun. I don't mean it flippantly, but short 3-hour mediations aren't, should we say, the most lucrative if you're a mediator, but they keep you engaged and they keep you into, very much, focused on, trying to get a resolution. And also having a time pressure is quite helpful because
Like
sometimes,
honing your mediation skills.
sorry,
It's like honing your mediation skills.
it kind of
So
is.
you're ready for the big game. Those are like the playoffs, but not the World Series or
Exactly. And it doesn't mean that you don't care. It doesn't mean that you're not as committed. And emotionally, I always find it just as draining to spend those 3 hours trying to get the parties to reach an agreement as I do in a 10, 12-hour mediation and all the rest of it, because there's that time is just ticking away all the time. But I think what I'm really trying to say on multi-party disputes is that I think that good mediators do a lot of the work that they need to do before the mediation. I don't. So I actually, funny enough, I need to follow up this afternoon with somebody on a mediation next week. I don't just mean about I've got a submission, I've got a paper that says, oh, this is what the case is about from one side. I mean, talking to them. Hey, I may not have mediated with you before. I don't want the first time that we meet to be at the mediation center. So this is what I look like if you want to see what I look like, or this is what I sound like. And tell me about your case. And the reason that I like to do that is because twofold. First of all, you have a certain degree of comfort with the mediator beforehand. And secondly, there may be some blindingly obvious issues. So a lot of parties will do a persuasive brief as to why you should pay or receive whatever it is that they're suggesting. And very often they'll leave out what's highly relevant. It's something that I'm not really a big fan of because when I was in private practice, we always used to have 2 sections. We had the first section, which we said was confidential, but we didn't really care whether it was. And then we had the second section, which was really, really confidential. And the reason it was really confidential was because the other side had some really good points. And we wanted the mediator to know that that the other side had those really good points, because the last thing we wanted was the mediator turning around to us and saying, oh, by the way, at the end of the first session, why haven't you addressed this, this, and this? And so I think that if you have those conversations beforehand, that doesn't mean you're arguing, it doesn't mean you're negotiating, it doesn't mean you're starting a mediation before the mediation itself starts. But what you're doing is saying, look, I've heard you. I've identified what your case is about. I understand what your case is. And in addition to which, just off the top of my head, these are some issues that you're going to have to address. So if you're going to come to the mediation next week, make sure you have them because they're going to be issues. And I think that really just comes down from experience. The more, sounds terrible, the older you are and the more experienced you are, probably you've come across it before.
I mean, it's just a reality as well. You literally are more experienced.
Yeah, there is. I do think it helps. There are a lot of people who say, well, maybe it doesn't, maybe I don't know. I think there's an advantage of having somebody who's got experience, provided it's relevant experience and provided they're still in touch. So I spend a lot of time going to courses. I spend a lot of time going to presentations. I talk to defense lawyers, I talk to plaintiff lawyers, I go and talk to commercial litigators, I go to CEO GC sessions because I want to make sure that I understand what's important for them and also what their language is. So if you're talking to a GC, the chances are it's very different if you're talking to one of the parties in a casualty case. Just very, very different.
Um, and the question, and I just lost it.
Sorry, I've been talking way too much.
No, that's okay. I mean, it's interesting. It's really neat to hear your perspective. And the thing I like when a guest is just really talkative is you can tell they have expertise. You can tell they have experience, right? You can tell that they know what they're talking about and they're passionate about it. And it's an area of law that some people probably never think twice about. But to hear your fervor, to hear how passionate you are about it, I think is good, is refreshing, and it even, if I dare say so, sells you as somebody who is passionate about what they do, even if it's passionate about being neutral, which sounds very funny when you think about it that way, but it makes sense, right? So let me shift footing here a little bit because there's a couple questions I did want to get into. I know that you have a lot of international experience. I know that you work in Georgia right now, but you also work around the country. You've worked in places like California, you worked in New York City, you worked all over the place. What's the difference between mediating a case in Georgia or New York or California? And how does that differ from mediating internationally?
Oh my goodness. That's a
Small question.
very, very long question to answer anyway. I think if I start in the States, New York is probably one of the few places in the world where having an English accent doesn't help. I've got to be straightforward about that.
I
I
was
don't
truly going to ask you if you thought that your accent was a boon or a benefit to you, because here in the States, in most places, like, oh, he's
most places, but not everywhere. Not in New York, for
not
example.
fair
Um,
enough.
Although having said that, I've got some great clients in New York who come back to me on a fairly regular basis, so they must appreciate something that I do. I think New York tends to be fairly quick-ish, by which I mean. And it's kind of interesting. The mediators I like in New York, they tend to be right to the point. There's just no faffing around, what about so and so, so and so, and so and so, and they just get straight into it, and they do it in a fairly aggressive way, which is very different from California, which is, oh, what do you think? Oh, well, what do you think? So it's a slightly different approach in my personal opinion. Um, and then you have places like Texas, where some pretty significant cases, it's a 4 hour. That's it. 4 hours in the morning, 4 hours in the afternoon, we're going to settle this case or we're not going to settle this case. People kind of don't have as much time. New York, they kind of do have enough time, but the numbers are quite large in New York anyway, for the cases I've been fortunate enough to be involved in. So I think a lot of it really is just understanding who the lawyers are. And I think that is the key to everything. If you talk to your lawyers before you mediate a case, you're going to learn a lot about them. you that half an hour, I mean, sometimes I spend an hour on the phone with them. And I'm not doing it to kind of clock up hours. I'm just doing it because I genuinely want to know who it is that I'm going to be mediating with and what their style is, what they like. So you get certain people who just, should we say, the law seems optional. And in that case, that's kind of difficult. You kind of say, look, you've got a very technical lawyer on the other side. They're going to want to talk about these cases. How do I know? Because they've told me, and they've told me they've briefed you on those cases in their briefs. So, you know, they're going to want to talk about them. So it's up to you. And so I think that you learn a lot by doing that. And I think it's really the same throughout not just the US, but actually also internationally, is taking the time and listening, which is massively ironic because I'm now on a podcast when I've just been talking almost incessantly since I started. But that's really what it is. You're trying to learn as much information as you possibly can from people, and you're trying to store that information and say, hey, that's interesting. I kind of probably learned more about negotiation in India than anywhere else. I was very, very fortunate. When I was a young attorney, there weren't a lot of international law firms with offices all over the world. They were in aviation, obviously based in London. A lot of it was, and so you used to fly out, and I used to fly out to India quite a lot. And I know when I look back, I was absolutely clueless. I had no idea what I was doing. But what I did know was to shut up and listen and let people talk for as long as they wanted to talk. Most people generally talk themselves out of whatever passionate position they happen to be in, if you give them enough time. But I say most people, it's not always the case, but you have to allow people because sometimes people just want to vent. I mean, probably one of the advantages of having, two teenage daughters is that, I'm pretty adept at listening to them vent, and I have learned. And I wouldn't say it took me overnight. It took me years and years. Sometimes you just need to sit back and listen. And Justin, if you're not in that position yet, you will be, I can assure you. Uh, so I think internationally, a lot of it is, you have to be culturally sensitive to whatever's going on. But culturally sensitivity doesn't mean that you have to accept something. The number of times I have been told, it's been sworn on whatever religious position has been adopted that this is the absolute truth and gospel. And, you're looking at a document and you can see that, well, the document seems to appear to say something completely different. So instead of accusing somebody of being inaccurate, you say, well, okay, this appears to be inconsistent. So the question is, what's going to be more important to the court? Is it going to be the document or is it going to be the argument? And that's really why we're here today, because these are what the issues are going to be. And so I think, if you're negotiating internationally, I think you have to be sensitive to what is going on in that particular jurisdiction. I mean, I did a lot of fatal accident cases, and a great example would be in Japan. There's a mourning period. You can't contact anybody during that mourning period. And if you do, it's incredibly rude and insensitive. You've just got to be aware of those sorts of things. Commercial disputes, again, you've got to be very careful. I'm by birth English, and I think the English are probably adept at saying one thing and meaning something completely different. You just have to be aware of these things, and you just have to take your time and allow people to get to wherever it is they need to get to share information. Because I think, as I said earlier, really negotiations about in a mediation is you're exchanging information for a better understanding of your risk assessment.
How long is the mourning period in Japan? I'm curious.
It's been a few years.
Hey.
It's at least 30 days. I do know that. God, it might even be 60. That's terrible. I should know. But it's been quite a few years since I've
It at least gives me a time frame. It's not like 6 months or a year. It's
no,
give him a week, give him a month, give him two
yeah.
months. That's interesting. I never heard that. So there you go, folks. You're always going to learn something new here. Except for the two of you that are from Japan, and you already know that. But um, Well, it's a lot of really good insights, and I really do appreciate you sharing everything with me. What, Nigel, would you say is when people hire you and they bring you in, what's one of the most frequent misunderstandings that they have? What's one of the misconceptions about who you are and what you do that they bring in when they hire you?
Well, first of all, because of my accent, people seem to think that I'm fresh off the boat. I've actually been here for 20 years, practicing for most of that time frame, and certainly been involved in the legal profession for over 20 years in the US. And I think that's probably the biggest misconception. And I think also that I'm on someone's side because I'm not. I genuinely want to get the case resolved. Um, and I think probably one of the most difficult things for a mediator is when the parties agree to resolve the case and you feel that one of the sides is getting a complete steal, if I can put it that way, because that is very, very difficult. That may not be a mis. I think the misconception is I don't care, things I do care, but that's not what my role is. But I'm fortunate that generally speaking, I think people make a decision, they have their own reasons for making a decision, and you need to respect that. So I feel that's pretty good.
So if they've come to a resolution and you do think that one side is totally running away with it and the other side is getting a raw deal, at that point, because they're coming together and agreeing, fundamentally you start to let go of the reins. Is that more or less accurate?
Yeah, I think so because I think you have to make it quite clear that it's their decision, it's the attorney's decision with them, and they need to discuss it. Whether it's on the whichever side it happens to be on. Because generally speaking, but also the other thing is you just don't know what's going on behind the scenes. There might be great reasons. I used to say years ago, I say years ago, I used to say that I could settle any case, which of course is completely untrue, but it's a boast I used to say. I could settle any coverage case for $1 million, $3 million. Could get it settled, definitely. I understood that. Wasn't a problem. What I couldn't do was settle a case that was $10 million because no one's interested what the mediator has to say because the mediator, hey, there's mandatory mediation on most reinsurance insurance contracts of that magnitude. Yeah, great to see you, Nigel. Really delighted you're getting paid, but we're going to get a trial. We're going to get an MSJ. We're going to do whatever it happens to be. And then, shockingly, I managed to resolve quite a significant eight-figure case, and I was kind of like, hey, I can't say that. And then I did another one, and what was really interesting about those cases wasn't that it was my analysis of the law that helped the parties. It wasn't. It was really understanding the risk and the financial imperatives of both sides that was more important. So, for example, knowing when should we say if coverage, when renewal was, knowing the impact of year end, knowing about succession planning within that particular organization, knowing about cash flow management of one or more of the parties. Those sorts of things, I think, are really, really important for your mediator to explore throughout the day because those are the reasons why cases ultimately get settled. They don't get settled because you've got a great mediator. Um, they might get settled because you've got a good mediator who gets you to confront the realities of the situation that they're facing, or the other side or other sides to face the realities of they're facing. But generally, you've got to look at a mediation as a voluntary process. Um, Completely different from arbitration, of course, where you are looking for lots of opinionated people, such as myself, to actually give a ruling. Different skill set, but two sides of the same coin in a way. You still need to be neutral. You still need to hear the evidence. You still need to answer the questions, and you still need to be, in my view, as clear as you possibly can. And I'm a little bit fanatical about conflicts of interest, and maybe it's because it's supposed to be significant in the UK. I'm not sure if it is, but I grew up in an era when that was taken very, very seriously by the firms that I work for. And so I do take conflicts of interests and interests. Like in Georgia, for example, the Uniform Mediation Act, requires you to disclose to the parties how you know everybody. Well, I always tell people, oh, well, I know them because I had a coffee with so and so. Why not say it? The last thing I want is for somebody to turn around from a mediation, have buyer's or seller's remorse, and then start saying, well, hang on a moment, did Nigel know so and so? Or how did we end up with Nigel as the mediator? And you have a post-match analysis, um, and you end up, being, a best, a best barred from get another case. But anyway, I'm digressing. So.
No, it's okay. I have a couple more questions for you, and we'll probably wrap up and we'll take up your entire day. And you apparently have someone you need to contact, so don't forget to do that after this
I do,
call.
yeah.
Um, Tell me, I asked you earlier about one of your biggest failures, and you were very candid, but I didn't ever actually got a chance to ask you the flip side of that question. What's one of the things, Nigel, in your legal career that you're most proud of?
Well, I think as a mediation career, I would say getting that case settled, that eight-figure case. When I was told by the parties that they've never had a case settle like that on the first mediation. And I think I got it settled because I asked the right questions, I got the right information, I was allowed to share that information, or I took lucky guesses, if you want to call it lucky guesses, and was able to share with both sides why I felt that they should move from whatever position they were doing. So I felt pretty strongly about that. In terms of um, uh, and it's kind of related to mediation. It's really why, in some ways, why I got into mediation to begin with. When you do international aviation liability cases, the reality is that you, generally speaking, for international carriage, had a limitation of liability sort of argument, and so everything was just a negotiation. And I remember resolving one case in a foreign jurisdiction and getting it done start to finish within 6 months. Everybody got settled. And I felt really, really good about it. Not because I had paid the absolute minimum, but because I had paid the minimum. I had paid the maximum that enabled me to get instructed a second time, which which is probably a terrible reason, particularly if you're on the other side. But I do feel that having a proper strategy, is in terms of negotiation, it's just something that's really important. And I just don't think people do it enough. They don't take resolution of their claim as seriously as they do the prosecution or defense of their claim. And I wish that parties did.
Gotcha. No, it makes sense. And yeah, no, 100%. So I'm gonna we'll have a hard out here in the not too distant future. I want to make sure I get a chance to ask you my two fun closing questions. So here in a minute, I'm gonna do exactly that. I'll give them to you right now so you can percolate on them while we're talking. And then I'm gonna jump over and give another shout out to your law firm, Henning, as well as read from our last sponsor. Question number one will be, Nigel, if we were to go back in time and maybe 30 years ago, meet young Nigel, and you're able to whisper something in your ear, give yourself one piece of advice, other than the obvious, which we all know is buy a lot of Bitcoin and hold it until it hits okay, obviously, right? Uh, but you're
That
able
would
to
be
give
good.
yourself
Yeah.
some advice. What advice would you give yourself and why? And then the second question is going to be, if I gave you my magic pen and you could make one change to the law, this could be international law, this could be a national law, this could be a state law. It can have sweeping ramifications at the international and national level. It can have the most minuscule of ramifications that just affects traffic tickets or forms you have to fill out in triplicate 5 times a week, right? What law would you change and why? While you're percolating on that, we're going to jump back over again and take a look. So again, I am talking with Nigel Wright. He is currently a mediator over at Henning, henningmediation.com. If you go to neutrals up at the top, I believe he is on the bottom. He's one of the newer guys there. I don't know, maybe that's just alphabetical, actually. I guess that's
Yeah,
probably
it is alpha. Of course, I have the name of Wright, so I'm right at the very end.
I'm West, so I feel your pain, but you're actually you got it worse than me because you're WR. I'm at least WE.
Yeah.
But anyway, that is henningmediation.com. If you have an issue that needs mediation, you can also reach them at 770-955-2252. Our last sponsor for today is Habanero Social. This episode is brought to you by Habanero Social. What if Google could send you free customers or clients every single month? With Habanero Social, it's not a fantasy, it's a reality. Their AI-powered platform optimizes your Google business profile to attract more local customers effortlessly and turn them into clients. From cranking out high quality content to managing reviews and fine tuning your local SEO,
Hmm.
Habanero Social handles it all while you sit back and watch your business grow. 85% of local searches happen within the Google Maps pack on page one of Google. That's the place you need to be if you want to capture those customers or clients. An optimized Google Business Profile doesn't just show up, it engages. It builds trust, increases clicks, and ultimately boosts your business. And Habanero Social is so confident that it'll work for you, they offer a 3 times ROI guarantee. They guarantee you will make at least 3 times what you spend with them, or they'll make it right. Stop wasting time on old school tactics. Habanero Social automates everything you need to rank higher, engage better, and drive more clients to your business. Ready to do more with clients without lifting a finger? Visit habanerosocial.com and let their AI, Samwise, do all the lifting for you. That's habanerosocial.com. All right, so Nigel, somehow you and I, maybe Doctor Who, I don't know, magically we travel back in time and we meet young Nigel. And you're able, without breaking the space-time continuum or triggering some weird butterfly effect, to go and just give yourself some advice. What advice would you give yourself at the beginning of your career to shape the trajectory that you had?
I think that's really easy. I think just be nicer. When I think back of
You
my
seem
old
so
job,
rude. I've been really offended this whole time.
I
So
do apologize. I kind of feel that I know, when I first started out, I was at AM 100 law firms. I was a partner there, and I was probably somewhat arrogant to say the least. And I think if I can go back in time, it would be just stop. Just like be a little bit nicer, or be nicer. I think that's what I would like to have done a little bit more of. I mean, obviously, I think I'm there now, but it's taken me a while to get there. I think that's probably the one thing I would want to have would want to change a little bit. The other thing, which is slightly work related, is when I was in house with the insurance carriers, a couple of them, yeah, I was really obsessed with not getting involved in attorney selections, because my job was to sort out the mess if the team had actually selected the wrong attorney for whatever case was. And so I didn't want to get involved, which of course is probably the most ridiculous thing to have done if you have any interest in becoming a mediator at a later stage. So that's probably, so I now know like one lawyer in every jurisdiction, but it would have been nicer to have known 20 lawyers a lot better in every jurisdiction or a couple of jurisdictions. So there's that. And then in terms of change to legislation, it's kind of an interesting one because uh, I think it depends whether you're a plaintiff or defendant. I think if you're a defendant, you always want more information. If you're a plaintiff, your view is that you don't want the other side to delay it. In my personal opinion, you want to get on with the case. You want to be able to. You don't want unnecessary motions trying to limit what you can and can't say. You just want the case resolved. So, with that having been said, if I really think about it, and it's very topical, particularly here in Georgia, there's a new piece of legislation, which is SB 68, which has addressed, it's basically tort reform in Georgia. And whatever the rights and wrongs of it, I'm not interested, shall we say, in the rights and wrongs, because for a lot of my clients, it doesn't make that much difference. It does for some, but generally speaking, it doesn't. But there is one aspect of it which really concerns me. And the reason is that there's a part of that legislation allows for one of the parties to a dispute to request bifurcation of any trial. And if you think about it, if you have bifurcation, it generally makes settlement harder. So I think as a mediator, I'm thinking, is that really a good thing? Now, the delta between what one after, so the reality is it's going to be harder to settle cases pre-liability trial. Um, Maybe not post-liability trial, but certainly pre-liability trial. It's just going to draw things out and increase costs. And I kind of feel that the parties who drafted this legislation had the opposite in mind. So that's just my 2 cents.
Right. That's a good 2 cents or pence, if you will. Well, Nigel, thank you very much for taking the time to talk with me today. I've really enjoyed your insights, and I can tell you're very sharp at what you do. I do always like to let my guests have the final word. Are there any last words of wisdom or parting thoughts you'd like to leave our listeners with?
Yeah, if you have a mediation coming up, talk to your mediator first. If you have never mediated with them before, or even if you have, tell them, how are you going to help me? What are you going to do? Doesn't mean that they have to give you a strategy, doesn't mean that they have to, certainly shouldn't disclose what the other side has to do, but make sure you don't go into mediation until you know who your mediator is. And if that means you've just got to pick up the phone, pick up the phone.
It's good advice. I can't argue with that. Well, again, Nigel, thank you very much for taking the time to talk with me and my listeners today. This is The Attorney Post. I am your host, Justin West. I have been chatting with Nigel Wright. Nigel is one of the neutrals over at Henning Mediation. As always, we'll have a link down below to henningmediation.com. If you need a mediator, particularly if you're in the state of Georgia, they seem like they would be a wonderful resource for you. This is The Attorney Post, and while we do chat all things law and legal, this podcast should not be misconstrued as being legal advice. If you do find yourself in a situation where you're in the need of legal advice or a mediator, please seek out a competent attorney or mediator in your area who is skilled in the matters that you need help with. Obviously, if you live in Georgia, I think that Nigel would be a wonderful resource for you. So again, you can go to henningmediation.com down below and book a time to talk with him and figure out what's going on with your case. If you are watching this podcast on YouTube, we always appreciate a like, a subscribe, and a share. If you're listening on any of the podcast repositories, we also do appreciate you rating our podcast there and letting us know how you feel. But the most important thing you can do is if you know someone who would benefit from the knowledge in this podcast, please share this episode with them because they need the best information they can get in order to resolve their situation. Because as I always say, if you don't know your rights, you don't have any. Until next time, I'm Justin West. Thank you for listening, and bye-bye.